Hello and welcome. My name is Kevin Seiss and my presentation is on agency law and liabilities. A quick overview of what this presentation will consist of is definitions of agency, agency law, agency liabilities, authority law of agency, liability of the agent, examples, and my references. Agency is a legal term of art that refers to the relationship between a principal and an agent. Agency, agency relationship. An agency relationship is a legal relationship where one person, called the principal, allows an agent to act on his or her behalf. Agency law. Agency law refers to the relationship between a person or agent that acts on behalf of another person, company, or government, usually called the master or principal. An agency is formed when a principal asks an individual to make a delivery or name someone as an agent through a contract, leading the responsibility of the principal for actions made by the agent, while the agent's actions are like to those of the principal. This form of agency can be and often is enforced by written agreements made through power of attorney. Agency law is when business owners hire or designate people to perform tasks on their behalf. What agency law does is it provides rules controlling the way which the systems operate. It needs consent from both parties in oral or written agreement. Along with this agreement, the agent will take all the responsibilities and liabilities that he or she's agency may encounter. Agency liability. The principal can be held directly liable for the agent's actions or wrongful acts, giving rise to a civil cause of action. A principal can be held liable when the principal gave faulty instructions to the agent, the principal negligently hired the agent, the principal failed to properly supervise the agent. An agent can be held liable when an employee of the agent does not follow instructions given by the agent, an employee of the agent does wrongful acts towards client/customer, an employee of the agent gives faulty advice or advertising. At the end of the day, the agent is liable for all the actions that he or she's employees do. Authority law of agency. This is the authority that is given to an agent by the principal. Expressed authority. Contractually given authority to the agent from the principal, orally or in written, communicated in the third party. This means when an agent takes action on behalf of the principal and he is responsibly believes that this is how the principal wants the actions carried out. Basically, where the principal tells the agent exactly what to do. Implied authority. The authority of the agent performed acts that are reasonably necessary to accomplish the purpose of the agency. This is where the agent takes responsibility necessary to accomplish the objective of the agency. Apparent authority. In agency, the situation in which a principal leads a third party to believe that an agent has authority to bind the principal, even where the agent lacks the actual authority to bind the principal. This is where the agent takes action from the principal with a third party, and that third party reasonably believes the agent has the authority to do so or sell the product in the company's name. Liability of the agent. General agent for a disclosed or partial disclosed principal subject her principal to the liability for the acts done on his or her account, which usually accompany or are related to transactions which the agent is authorized to conduct if the other party reasonably believes that the agent is authorized to do them, although they are forbidden by the principal. A disclosed or partial disclosed principal authorizing an agent to make a contract is subject to liability upon a contract made in violation of such limitations with a third party who has no notice of them. A person who intentionally causes or assists an agent to violate a duty to the principal is subject to a liability in action for the harm such person has caused the principal or in compensation action for any profit such person derived from the transaction. Errors and omissions. Errors and omissions insurance (E&O) is a type of professional liability insurance that protects companies and their workers or individuals against claims made by clients for inadequate work or negligent actions. Errors and omissions insurance often covers both court costs and any settlement up to the amount specified by the insurance contract. Errors and omission protects professional agents when he or she's employees or themselves are taken into court by clients for their actions or advice. Examples. Some examples of agency examples: employee, employer, lawyer, client, corporation, officer. Also, realtors companies such as Remax and Keller Williams, a few insurance companies such as State Farm, Allstate, and Farmers. All these companies use agency contracts with their agents across the country. And this is the end of my presentation, and I want to thank you for your time.